Our first case for today takes us to Arizona, where we are looking at tribal rights as it relates to water. In the case of Arizona versus Navajo Nation, in this case, there is a treaty between the United States and the Navajo tribe that dictates some of its relationship with the United States. And there is a conflict over water, which is not at all a surprise when it comes to the western part of the United States. Water rights often an issue as it comes to who can access the water and when. Lots of water cases wind up at the US Supreme Court, surprising amounts sometimes, perhaps a little bit different in this context because it involves a tribe. Usually it's a conflict between states. This particular case with a tribe. So we're looking at the tribal relationship, the issue of the treaty, and what the United States can and cannot do versus Arizona versus the tribe as it relates to the water rights. Let's get started with this. An 1868 peace treaty between the United States and the Navajo established the Navajo Reservation that today spans 17 million acres, almost entirely in the Colorado River Basin of the western United States. The federal government's reservation of land for the Indian tribe implicitly reserves the right to use needed water from various sources such as groundwater, rivers, streams, lakes, and springs that arise on, border, cross, underlie, or encompass within the reservation. So standard property rule, of course, is that, when you buy land, you kind of get everything that comes along with it. At least in common law, when you had a piece of land, you had everything above it, everything below it, all the way to heaven and all the way below to hell. And you got everything that come along with it. Of course, in more modern times, as we understand more things, those rights have somewhat been ameliorated, but still there is a default proposition that the things on your land come along for the ride unless otherwise modified. While the tribe has a right to use needed water from the reservation's numerous water sources, the Navajo face the same water scarcity problems that many in the western United States face. Yeah, not the first time there's been a conflict over water in the western United States. Happens quite a bit. In the Navajo's view, the federal government's efforts to assist the Navajo with their water needs did not satisfy the trust obligation of the United States under the 1868 treaty. The Navajo filed suit seeking to compel the United States to take an affirmative step to assist the Navajo with their water needs under the treaty. So what the Navajo argue here is, we are a domestic dependent nation. Our relationship with the United States is at least partly informed by treaty. Arizona wants water. We want water. The United States are required to assist us actively in our help with the water. And you're nowhere to be found. So we think you're in violation of the treaty. Okay. In particular, the Navajo want the United States to help the tribe with developing a plan to secure needed water, build pipelines, pumps, wells, and other water infrastructure. The states of Arizona, Nevada, and Colorado intervene against the tribe to protect those states' interests in the water from the Colorado River. Because the river crossed many states, lots of people have interest in it. The United States District Court for the District of Arizona dismissed the Navajo tribe complaint, but the Ninth Circuit reversed, holding in relevant part the United States has a duty under the treaty to take affirmative steps to secure the water. Okay, so this is all a question of the treaty. What is the United States obligated to do when it comes to the water rights for the tribe? Let's learn more. The U.S. Supreme Court holds that the 1868 treaty establishing the Navajo Reservation reserved necessary water to accomplish the purpose of the Navajo Reservation, but did not require the United States to take affirmative steps to secure water for the tribe. So, yes, there is a treaty that Navajo Nation can look to. It does say that the Navajo Nation gets some water rights, which kind of come along with the land, as you would expect. But because the water crosses multiple states and multiple jurisdictions, you kind of have to share. And also, the United States does not have any particular obligation to defend your rights here. So, although you do have rights, you have to defend them on your own. The tribe asserts a breach of trust claim based on its view that the 1868 treaty imposes a duty on the United States to take affirmative steps to secure the water. To maintain the claim, the tribe must establish, among other things, the text of the treaty, statute, or regulation imposes a duty on the United States. The federal government owes judicially enforceable duties to a tribe only to the extent it expressly accepts those responsibilities, which presumably is true of not only a tribe, but anyone else, right? If there is a duty that is imposed, it is because of an obligation that the party has accepted in some sense. I mean, to some extent, this is just true of private parties as well, right? There's only a duty if the duty is created by something that a person does. Otherwise, there's no affirmative duty. So we look to the party's behavior and their contract or their agreement, or in this case, treaty, to see if there is a duty, right? So, for example, just by analogy, if I sell you a piece of land, right, that land comes with a whole bunch of rights, but I don't necessarily have any particular duty once I sell it to you to help you maintain or preserve those rights. So if someone else is interfering with your land, you go sue about it. It's not my problem anymore. I sold you the land. I sold you the assets of the land. I sold you the liability of the land. I sold you the obligation to maintain your rights to the land. It is your problem now, not my problem. So that's some of the things we're looking to, right? So if there's a duty that goes past the transfer of the land, we have to look to some obligation that was imposed by, or incurred by the parties in some sense. So that kind of makes sense. When the government has expressly accepted such obligations, must train on specific rights, creating or duty imposing language in the treaty, statute, or regulation. Fair enough, right? So we look to the statute, we look to the regulation, we look to the treaty, we look to the contract, we look to something that says, okay, there is an ongoing duty here. Fine. Here, while the treaty set apart a reservation for the use and occupation of the tribe, it contains no language imposing a duty on the United States to take affirmative steps to secure the tribe. Yes, this land is yours. Go fight for it yourself. It's your problem. Fine. Notably, the treaty did impose a number of specific duties on the United States, but the treaty said nothing about an affirmative duty for the United States to secure water. So sure, the treaty might contain other obligations, which, fair enough, but those obligations are defined by the agreement. In this case, the treaty. We look to the treaty and see what obligations does it create. Do you have some obligations? Yes. Is this one of them? No. All right, just because you have obligations to do other things doesn't mean you have obligations to do this thing. What obligations did you incur? And as the court has stated, Indian treaties cannot be rewritten or expand beyond their clear terms, which, fair enough. To some extent, this sounds just like contract law principles, right? The treaty is essentially a contract. We're looking at this kind of like contract law principles. We look to the four corners of the contract. What does it say? What obligations does it impose? Let's look to the language. Doesn't contain language imposing an obligation. Okay. To be sure, this court's precedents have stated that the United States maintains a general trust relationship with the tribes, including the Navajo. So unlike a typical land contract, where I sell you land as a private party and we are just completely done with each other, we are totally private parties and never the twain shall ever meet again. Here, that is not completely true. The United States has some kind of trust relationship with the tribe. So they can't just necessarily transfer the land and be completely done with it, because they maintain some overall obligation to act in trust. And as a trustee for the tribes, they have some affirmative obligations to the tribe as a trustee. So again, you can kind of look at this as private parties language, right? If you were engaged in a private trust with someone, that person has a duty to you because they have undertaken the duty by being in the trust. They are obligated to you as the trustee, as the beneficial party, to execute the trust in a way that furthers your interests because you're the beneficial party, right? Okay, that makes sense. So fine. But unless Congress has created a conventional trust relationship with a tribe as to a particular trust asset, this court will not apply common law trust principles to infer duties not found in the text, structure, regulation. All right. So what we have here is a distinction between common law trust, which I just described to you, right? A trust is where you have some property. It's been delivered to a trustee. There is a noted third-party beneficiary and an agreement to form the trust, right? That's all that's required to form a trust. It doesn't necessarily even have to be in writing in common law, incidentally enough. You can just do it orally, right? So if I say, okay, I'm giving you this property for the benefit of someone else. So just to give an example, right? Okay, I'm giving you this property. I want you to give it to my daughter when they're 18. for whatever reason, I don't want to give it to them myself, or I think I'm going to be dead or something like that. So I'm giving it to you, give it to my daughter when they're 18. And you say yes. And I say yes. Great. We have the trust. I have delivered to you the property. We have formed an intent to a third party beneficiary. You are in possession of the property. You have agreed to be the trustee for the beneficiary of the third party. We have everything we need to be a trust. So your duty to the trustee is to execute it in relation to that. Now, in the case of deliver the thing to the person, there's not a lot of like wiggle room in that, because how wide can you interpret it? But if instead I said, here's $1 million, I want you to invest it for the benefit of my daughter and then give it to her when she's 18. All right. So now you now need to invest the property, so you have discretion, but you have to execute it in a reasonable way. But here, this trust relationship is not quite like that. It's not quite fiduciary duty to the trustee. So it is a little bit lighter of a form of trust than a conventional trust. So yes, there is a general trust relationship that exists kind of in the ether, that kind of exists, but not with respect to any particular property. Okay, so that's an interesting idea. Here, nothing in the treaty establishes a conventional trust relationship with respect to the water. So we have a duty to you very vaguely as a tribe, but not with respect to the water. So I guess we're kind of looking at this as a guardianship relationship, for lack of a better description, right? The tribe is our ward, and we have a duty to them as effectively our child, right? And that doesn't necessarily mean that in execution of that duty, we have a duty to them with respect to any particular item or property, right? So you as a parent have a duty to your children. That doesn't necessarily mean that with respect to any particular item of property, you have a particular duty, right? Your duty is in a more general sense. You must work for the overall benefit of your child. So if you sell, one of your child's assets for the overall benefit of your child, they don't have a right to sue you. So that's kind of what we're looking for, right? This is a very general, more vague trust relationship. Fine. More akin to a guardianship agreement. Okay, fine. And it's unsurprising the treaty enacted in 1868 did not provide for all the Navajo current water needs 155 years later. Under the Constitution, Congress and the President have the responsibility to update federal law as they see fit in light of contemporary needs. So the agreement is the agreement. It's 150 years ago, but so what? The agreement is the agreement, and the agreement is still the agreement 150 years later. So maybe realities under the ground have changed, but the agreement is still the agreement. Fine, I understand this. Other arguments offered by the Navajo tribe to support its claim under the treaty are unpersuasive. First, the treaty establishing the reservation as a permanent home does not mean the United States has agreed to take affirmative steps to secure water. Second, the treaty's express requirements that the United States supply seeds and agriculture implements for a 3-year period to the tribe does not, as the tribe contends, mean the United States has an additional duty to take affirmative steps to secure water, but rather demonstrates the United States and Navajo knew how to impose specific duties. So the treaty says for 3 years, I will continue to supply you this kind of stuff. The 3 years expanded, the 3 years ended quite a long time ago. So not so much there. Third, the tribe asserts that the United States purport control over reserved water rights supports the view the United States owes trust duty to Navajos, but the federal government's liability on breach of trust claim cannot be premised on control alone. So again, they have control over the whole thing as a trust, but the general does not necessarily imply the specific is basically what we got on here, right? The general does not imply the specific. You have a general duty to the person, but it does not imply the specific obligation to do specifically this. So, fine. Finally, the text of the treaty negotiated does not support the claim the Navajos would have understood the treaty to mean the United States took steps. So again, we're looking at this kind of like contract language, right? We're looking to the understanding between the parties. So in contract, we look for meetings of the mind, right? What did the parties understand the contract to mean? So we look to the exact language of the contract, which is informative. We call it a treaty here, but we're basically treating this like a contract. So it's a contract. It's just a special one, and we give it a special name called a treaty. It's a contract, though, right? So we look to the language of the contract, it tells us one thing. And then we also say, okay, we can look to other things outside the contract to say, did they have some private understanding of private terms? Did they understand certain terms to mean certain things? And based on things, this contract language affirms the meaning of the minds. So there's no conflict here. So we just go back to the four corners of the contract and call it a day. So yes, it's your land. Yes, we give it to you. Yes, we have a general duty to you in a very general way, but no, not so much specifically with specifically exactly the water. Go fight for the water on your own terms. I understand all these things. Kavanaugh delivers an opinion in a 5-4 split decision. Thus, that brings us to the end of the decision of Arizona versus Navajo Nation, a contentious issue dealing with both tribal rights, which are contentious, and water rights, which are perhaps even more contentious, especially in the western part of the United States. Water and access to water is something that the western states and western jurisdictions fight over quite a lot, as you would expect. It's a little bit dry out there. You might have heard about the deserts out there in the west, and there's a lot of need for water and not necessarily enough to go around. The Colorado River might be mighty, but as it happens, not mighty enough to satisfy everyone's needs, which are insatiable. The Navajo Nation over here is basically effectively in the same position into this particular respect as many of its brothers and sisters out there in the desert west. And it's like, we need more water. I understand Navajo Nation, but there's not enough to go around. And they say, look, the United States has an obligation to us under treaty. And the United States interpreting the treaty, much like a contract as it relates to a giving of land, looks at this and says, okay, the United States gave you this land in an agreement. They gave you the land, and we look to the contract. The contract says, yes, they have a continuing duty to you in a very general way to help make sure that your land and your rights are preserved. But the general does not imply the specific. The general duty to you in a very general way does not necessarily obligate them to do this specific thing. They are obligated to you as a trustee in a very generalized sense. So as long as they're kind of furthering your interests, and I know you're sad about the water and all, but you still have the land and they're not interfering with your rights. They're just not going to actively help you. So you go fight for your rights on your own. So if we interpret this as just a matter of contract in relation to a piece of land and looking at generalized trust principles and how we deal with trust and inference of trust, then a lot of this makes very sense. So if we translate this from tribal to and treaty to more common law concepts, this is very understandable. We would do kind of the same thing as it relates to contract and the same thing that relates to trust as it relates to other things. This language makes sense to me. So hopefully it makes sense to you. And that brings us to the end of discussion of this case.